A company cannot type, click, or disclose information by itself. It acts through people, policies, code, and delegated systems. Yet the company is a legal person, and Section 85 of the Information Technology Act can connect organisational contraventions to both the company and individuals responsible for the conduct of its business. That does not mean that every director is automatically guilty whenever an employee misuses a computer. It also does not mean that a company escapes because a junior worker performed the final act. Episode 12 builds the connections. Our fictional composite, Riya, discovers that a security approval control was deliberately disabled before a sensitive data export. A manager had received earlier warnings about the weakness. An engineer executed the configuration change. A contractor used the resulting path. Which acts are contraventions or offences? Who abetted whom? Was there an attempt before the final event? Did the manager consent, connive, or neglect? Or did the manager exercise due diligence? What can be attributed to the company? The answers require evidence about role, responsibility, knowledge, control, and causation, not an organisation chart alone. We will also place Section 85 beside the residual enforcement provisions from Sections 71 to 78 and the general abetment and attempt provisions in Sections 84B and 84C. The Jan Vishwas amendments changed several consequences, so current consolidated text must replace old criminal law summaries. Some provisions now impose monetary penalties, where older articles still describe imprisonment. Others remain offences. The method is to read each current section, identify its actor and mental element, then map the facts. No real company or person is accused in Riya's scenario. Its purpose is to show how corporate accountability can be rigorous without becoming guilt by title. The Jan Vishwas Amendment of Provisions Act 2023 rationalised consequences across many central laws, including the Information Technology Act. The IT Act amendments were brought into force on November 30th, 2023. Several provisions that older books describe as criminal offences were changed into monetary penalty provisions, and Section 46's adjudication wording was widened from contraventions under one chapter to contraventions under the Act. This means that an apparently authoritative article written before the commencement date may give the wrong present consequence. Do not update a penalty by memory. Read the Consolidated India Code section and its amendment notes. For each provision, capture 5 items: the actor, prohibited or required conduct, mental element, if any, present consequence, and decision maker. Section 72 is a useful example. It now provides a monetary penalty, up to the current statutory maximum, for a person who obtained access in pursuance of powers under the Act, rules or regulations, and discloses protected material without consent, subject to the section's wording. Older summaries often still describe imprisonment. By contrast, Section 72A, concerning disclosure in breach of lawful contract with the required intent or knowledge, remains framed as a punishment provision. Section 74 also remains an offence concerning creation or publication of an electronic signature certificate for a fraudulent or unlawful purpose. The enforcement map is therefore mixed, not uniformly decriminalised. Riya's team should avoid writing one incident report that calls every breach an offence. The report can identify possible sections for legal review, state observed facts, and let current text determine whether the route is adjudication, compensation, or criminal process. In compliance work, update policies, training, and escalation matrices when statutes change. A control designed around the wrong forum may send notice to the wrong person, mislimitation or describe an employee as criminally accused where the current provision creates a civil penalty. Accuracy is part of fairness. Section 71 addresses misrepresentation to, or suppression of a material fact from, the controller or a certifying authority for obtaining a licence or electronic signature certificate. Its current consequence should be read from the consolidated text after Jan Vishwas. The provision protects the certification system at the point where public trust is granted. An inaccurate minor detail is not automatically the same as deliberate suppression of a material fact. The language and evidence matter. Application records, communications, identity material, and decision significance help establish the proposition. Section 72 protects a different relationship. It applies where a person, using powers conferred under the IT Act, rules or regulations, secures access to an electronic record, book, register, correspondence, information, document, or other material, and discloses it to another person without the concerned person's consent, unless another law or the Act provides otherwise. After Jan Vishwas, the section is a monetary penalty provision. Its actor is not every employee who sees confidential data in ordinary business. The access must arise in pursuance of the specified statutory powers. That narrow starting point distinguishes Section 72 from contractual confidentiality, data protection, and other disclosure rules. Riya's company employs an auditor who reviews records under an IT Act-related authority and later sends an extract to a friend. The analysis asks how the auditor obtained access, what material was disclosed, whose consent was absent, and whether any lawful exception applied. If an ordinary vendor employee discloses customer data received under a service contract, Section 72A or another law may be the more relevant route. The word privacy in Section 72's title does not turn it into a universal privacy code. Good legal analysis begins with the operative text, not the heading. The corporate response should preserve access records, the authority under which access was granted, the disclosure evidence, and any approved sharing route. It should also contain the disclosure and notify through applicable channels without assuming the final legal character before the access basis is known. Section 72. A addresses disclosure of personal information obtained while providing services under a lawful contract. It requires the specified intent to cause, or knowledge that disclosure is likely to cause, wrongful loss or wrongful gain, and disclosure without consent or in breach of the lawful contract. This is not strict liability for every accidental email. The source of information, contractual relationship, consent, disclosure, mental element, and wrongful effect must be proved. Other contractual, data protection, or negligence consequences may apply even where the criminal elements are not established. Sections 73 and 74 protect trust in electronic signature certificates. Section 73 restricts publishing or making a certificate available with knowledge that the listed certifying authority did not issue it, the subscriber did not accept it, or the certificate was revoked or suspended, subject to the statutory wording and limited verification purpose. Jan Vishwas changed the consequence in Section 73, so old imprisonment summaries should not be repeated. Section 74 remains an offence where a person knowingly creates, publishes, or otherwise makes available an electronic signature certificate for a fraudulent or unlawful purpose. The two provisions should not be collapsed. Section 73 focuses on specified false trust conditions. Section 74 focuses on knowing fraudulent or unlawful purpose. Riya's team finds a fake procurement portal displaying a copied certificate that has been revoked. Preserve the page, certificate data, server and platform records through lawful means. Determine who made it available, what they knew, and the purpose. Do not conclude that the real certificate subscriber created the portal merely because their name appears in the copied certificate. The certificate may be the object of misuse rather than proof of the subscriber's involvement. Corporate response should notify the certifying authority through verified channels, warn affected users carefully, and coordinate takedown and law enforcement without destroying evidence. The wider lesson is that digital trust law protects both the issuance process and reliance after issuance. False identity, false status, and fraudulent purpose are related, but each current section has its own root. Section 76 allows confiscation of specified technology and data connected with contravention of the Act, rules, orders, or regulations. The section's protection for a person who is not responsible and has taken necessary precautions matters in modern environments where devices are leased, accounts are shared across services, and employers own equipment used by individuals. Confiscation is not a shortcut from possession to guilt. The authority must connect the resource to the contravention through the statutory process, and affected interests can require examination. Section 77 then says that compensation, penalties, or confiscation under the IT Act do not interfere with compensation, another penalty or punishment under another law. This preserves possible overlap. It does not declare that every available consequence must be imposed or that a claimant may recover the same loss twice. Map each consequence to its purpose, legal source, decision maker, and target. Riya's company laptop was used to disable the approval control. The company owns the laptop. An engineer held it. Remote management logs show commands. Another account approved the change. Confiscation analysis concerns the device and its use. Criminal attribution concerns the actor and mental element. Company liability concerns responsibility and corporate conduct. Compensation concerns caused loss. They may share evidence without becoming the same issue. If a device contains material belonging to innocent customers, preservation, privacy, and access controls remain important during seizure or forensic work. If the company asserts innocent ownership, it should show policy, precautions, monitoring, response, and lack of responsibility, rather than simply produce a purchase invoice. Conversely, the mere existence of a security policy does not prove necessary. Precautions were taken if the control was disabled for months. Section 76 encourages careful asset and evidence records. Section 77 encourages a complete consequence map. Together, they warn against both under-analysis, assuming one order ends everything, and overreach, assuming that multiple legal labels automatically justify cumulative punishment without examining statutory limits and fairness. Section 77. A permits a competent court to compound eligible IT Act offences and sets exclusions, including offences with life imprisonment or a term exceeding 3 years, specified repeat conviction situations, offences affecting the country's socio-economic conditions, and offences against a child below 18 or a woman. A company and complainant cannot privately promise that an ineligible or public offence will vanish. Settlement discussions should be led by counsel and should not suppress evidence, interfere with witnesses, or replace mandatory reports. Section 77. B classifies offences by punishment for cognizability and bailability, while Section 78 states that a police officer not below the rank of inspector shall investigate an offence under the Act. The rank rule is important, but it does not make every action by an inspector lawful. Search, seizure, arrest, access to devices, and collection of evidence still require the powers and safeguards applicable to the facts. Episode 8 covered those routes in detail. An internal corporate investigation is different again. The company can preserve its systems, interview staff under policy and contract, and take employment or security action within lawful bounds. It cannot assume police powers or force access to a personal device without authority. Riya's employer launches an incident review and simultaneously informs law enforcement through counsel. The internal team protects logs, isolates accounts and documents configuration history. The police investigate the alleged offence. The teams coordinate to avoid changing evidence, but their purposes and powers remain distinct. If a potential settlement later arises, the competent court and Section 77A eligibility control the criminal compounding route. This separation protects the investigation and the company. It also reduces the risk that an employee interview is described as a confession obtained by state authority when it was an employment process, or that a corporate image of a device is treated as lawful simply because the company suspects crime. Rank, power, purpose, and evidence chain must all be identified. Section 84B supplies a general punishment for abetment, where the abetted act is committed as a consequence, and the IT Act does not make an express separate provision for that abetment. Its explanation connects consequence to instigation, conspiracy, or aid. The section can reach a person who did not perform the final technical act, but intentionally enabled the offence. That makes communications, access grants, instructions, payments, and division of roles important. It does not mean that every weak control or managerial mistake is abetment. Negligence, consent, connivance, and due diligence may arise elsewhere, especially in Section 85. Abetment asks for the intentional legal connection described by the section. Riya's engineer disabled the approval control after a manager wrote, "Remove the block tonight so the contractor can copy the records. We will put it back tomorrow." If authenticated and read in context, that instruction may be evidence of instigation or aid. If the manager merely failed to read an automated warning, the analysis may concern neglect rather than abetment. If the engineer independently misused an ordinary maintenance command, the manager's title alone does not fill the gap. Build the chronology. Who proposed the plan? Who supplied credentials or access? Who knew the target and purpose? Which act was committed because of that assistance? Was the underlying offence completed? Is there an express abetment punishment elsewhere? Preserve message metadata and context, not an isolated screenshot. Corporate chat can contain sarcasm, forwarded text, or edited exports. Authenticity and meaning require proof. Also distinguish legal advice or ordinary technical support from intentional assistance to an offence. A security engineer who explains a vulnerability so it can be fixed is not an abetter, because the information could be misused. Purpose, knowledge, and causal assistance matter. Section 84. B prevents a person from escaping merely by keeping their own hands off the keyboard, but it still demands a proven path from the person's conduct to the completed offence. Section 84C addresses an attempt to commit an IT Act offence where no express provision punishes that attempt. The person must do an act towards commission of the offence or cause such an offence to be committed. The punishment can extend to 1/2 of the longest term of imprisonment provided for the offence, or the fine provided, or both according to the section. The distinction between preparation and attempt is fact-sensitive. Buying a computer, learning a command, or possessing an ordinary administration tool does not automatically show an attempt. Conduct must be connected closely enough to the contemplated offence under the applicable legal test. On the other hand, failure at the final technical step does not necessarily erase liability. A person who sends exploit traffic directly at a target with the required intent may have moved beyond preparation, even if authentication blocks the intrusion. Always check the offence-specific section first. Section 70 expressly punishes securing or attempting to secure access to a protected system, so its own attempt language governs that context, rather than treating Section 84C as a universal overlay without analysis. Riya's case includes a script created to export customer records. The script was tested on dummy data, scheduled against production, and then stopped by a permission error. The code alone shows capability. The schedule, target configuration, messages, and credentials may show an act towards commission. Investigators must still prove who acted, the intended offence, and the proximity of conduct. If the export actually occurred, the completed offence analysis may supersede the attempt route for that act, though earlier attempts can remain evidentially relevant. In corporate controls, do not wait for completion before containing an evident attempt. Security can disable access based on risk while legal classification develops. Record the observed conduct and preserve the artifacts. Section 84. C punishes movement towards an offence. It does not punish imagination, professional skill, or mere possession of dual-use technology without the required connection. Section 85 begins with a contravention committed by a company. It states that the company and every person who, at the time, was in charge of and responsible to the company for conduct of its business, shall be guilty and liable to be proceeded against and punished accordingly, subject to the statutory defence. The explanation includes a body corporate, firm, or other association of individuals within company, and treats a partner as director for a firm. The section's language is functional and time-specific. It asks who was in charge of and responsible for the business conduct connected to the contravention when it happened. A director designation may be relevant, but it is not a substitute for evidence of role. A large company may have directors with no operational connection to the affected system, while a non-director executive may control the relevant business. Pleadings and proof must identify the link rather than name every senior person. Riya's approval platform belongs to the Data Operations Division. The Chief Financial Officer is a board member, but has no responsibility for that platform. The head of data operations owns the process, receives control reports, and approves vendor access. The security manager administers the technical control. The engineer executes changes. Section 85 analysis maps each role, reporting line, decision power, and knowledge at the relevant time. It also asks what contravention the company committed. Individual liability cannot float free of the underlying corporate event. Board minutes, delegations, job descriptions, access rights, risk acceptances, and actual practice can all matter. An organisation chart written after the incident carries less weight if daily decisions followed a different route. Companies should therefore keep responsibility maps current and align technical approval rights with documented accountability. The purpose is not to create sacrificial names, it is to make control ownership real. When responsibility is clear before an incident, Section 85 analysis is more accurate afterward, and operational response is faster because the organisation knows who can decide, contain and report. The first limb of Section 85 contains an important defence. A person is not made liable if that person proves that the contravention occurred without their knowledge, or that they exercised all due diligence to prevent it. Due diligence is demonstrated through actions suited to the risk: clear ownership, proportionate controls, training, access review, monitoring, escalation, remediation, and evidence that warnings were addressed. A policy downloaded from a template does not prove implementation. Lack of knowledge is also not simply a refusal to read reports where the person's role required attention. The facts determine whether the defence is available. Section 85's second limb operates notwithstanding the first. Where the company committed the contravention, and it is proved that it occurred with the consent or connivance of, or is attributable to neglect by, a director, manager, secretary, or other officer, that individual is also deemed guilty and may be proceeded against. This requires a specific culpable connection. Consent can be express or inferred from proved conduct. Connivance suggests knowing participation or turning a deliberate blind eye. Neglect connects failure of duty to the contravention. The exact legal meaning belongs to adjudication and case law, not a compliance slogan. Riya's data operations head received 3 high-risk findings, approved an exception with no expiry, and rejected funding for logging. Those facts may bear on neglect and due diligence. The head also ordered the engineer to disable the control, which may bear on consent, connivance, or abetment, depending on proof. The security manager documented the risk, proposed fixes, and escalated to the board committee. That evidence may support due diligence, but the manager's actual powers and remaining omissions still need review. Good governance records decisions and dissent, tracks remediation, and gives control owners authority proportional to responsibility. Section 85 does not punish hierarchy as such. It examines responsibility, prevention, and the proven relationship between corporate contravention and individual conduct. Now map Riya's facts without shortcuts. The engineer changed the approval configuration using an individual administrator account. A signed change record is missing, and chat messages show the data operations head demanded the bypass. The contractor then scheduled an export that failed once and succeeded after the control was disabled. The company retained the records and reported the incident through applicable routes. Start with the underlying contravention or offence. Identify the unauthorised acts, the affected computer resource, the data movement, permission boundaries, and any dishonest or fraudulent element. For the contractor, analyse the completed act and earlier attempt separately. For the engineer, determine knowledge and purpose. Ordinary maintenance, reckless compliance with an order or intentional aid. For the manager, examine the instruction, authority, knowledge and causal role under abetment and Section 85's consent, connivance or neglect limb. For the company, identify the business process, control failure and acts of responsible personnel, then examine due diligence. The security manager had escalated the exception, restricted other access and preserved evidence. The data operations head accepted the risk without authority and concealed the export. The CFO appears in the corporate hierarchy, but has no role in the data service or the control decision. Naming the CFO merely because the office is senior would weaken the analysis. Corporate records, technical logs, and authenticated communications should support each link. Employment action can proceed under policy and contract on its own standard, but criminal or statutory conclusions require the relevant legal elements and process. The company should protect whistleblowers, avoid coordinated witness stories, and maintain privilege where appropriate. It should also fix the control without overwriting the evidence, revoke access, restore approval, validate similar exceptions, and document remediation. The case ends with a liability matrix, not a headline. Each row names an actor, conduct, legal theory, evidence, counter-evidence, defence, and confidence. That matrix is accountable because it can change when better evidence arrives. Use 12 questions before assigning corporate liability. 1. What exact current IT Act provision is engaged, and did Jan Vishwas change its consequence? 2. What corporate contravention or offence is proved? 3. Which human act or omission caused it? 4. Who was in charge of and responsible for the relevant conduct of business at the time? 5. What authority and control did that person actually have? 6. What did the person know and when? 7. Is there evidence of instigation, conspiracy or intentional aid under Section 84B? 8. Did someone move from preparation to an act towards an offence under Section 84C, and does the offence itself contain attempt wording? 9. Did a director, manager, secretary or officer consent, connive or neglect under Section 85's second limb? 10. Can a person show lack of knowledge or all due diligence to prevent the contravention? 11. Do technical logs, communications, delegations and witness evidence support each link without assuming that account, device and human are identical? 12. Are regulatory, compensation, employment and criminal processes being kept distinct while evidence is preserved? Add the residual provisions carefully. Section 71 protects the trust application process. Section 72 addresses disclosure after access through IT Act powers and now uses a penalty route. Section 72. A addresses specified contractual disclosure with wrongful loss or gain intent or knowledge. Sections 73 and 74 protect certificate trust through different present consequences. Sections 76 to 78 address confiscation, cumulative consequences, compounding, classification and investigation. Riya's fictional company fixes the bypass, preserves the record and analyses each role without accusing an uninvolved executive. The lesson is not that senior people are immune. It is that accountability becomes stronger when it is proved rather than presumed. Episode 13 completes the series with India's privacy transition. We will use the official 2025 commencement notification, explain what is and is not in force on August 9th, 2026, map the DPDP framework scheduled for full substantive commencement in May 2027, and connect it back to IT Act Section 43A without pretending that future duties already apply today.